presided BSc meeting and he has informed the House already. Thank you. Now I will call list of speakers. Motion moved. Dr. Abhishek Manu Singhvi, please.
Honorable Chairman, sir, distinguished members of this august House, I rise to oppose this bill and seek substantial changes in its pernicious character. It is clearly designed for ulterior motives by a control freak Sarkar bent upon sending out a message of fear through the architecture of omniscient Orwellian surveillance for foreigners. As I will presently demonstrate, sir, this bill is a true work of art. A work of art for excessive, uncanalized discretion, for overbroad delegation, for delightfully vague phraseology, for deliberate omission of any alternative efficacious oversight mechanism, for elevation of a constable to the level of a super commissioner, a license for harassment, and all based on the fundamentally false assumption that foreigners have no rights under the Indian Constitution, as also the decimation of all notions of privacy and autonomy of an individual. Sir, members of this august House, from dreams of being a Vishwaguru and enveloping the world in India's embrace of soft power, from talking of Atiti Devo Bhava, this bill sends a message that all foreigners are potential criminals, to be viewed with serious suspicion by India, where India is to act as an unwelcome fortress for its unwanted non-guests. Sir, if these words seem too harsh, let me try to make each word good in a moment. Sir, let's look at excessive delegation. Excessive delegation to lowly officials with a humongous breadth of discretion on those officials is the visiting card of this bill. Start with the heart and soul of the bill, clause 3, which by the way has no predecessor in any of the earlier 4 enactments which this bill pretends to consolidate. 1920, 1939, 1946 and 2000. No predecessor is found of this section, clause 3. The first proviso to this clause 3 has a big non-obstant override to the whole clause by empowering the central government to refuse entry to or deport any foreigner on grounds of national security, sovereignty, integrity of India, foreign relations, and curiously, public health. So far so good. We understand these grounds, they are serious, and foreigners attaching to these grounds must be dealt with. It then adds, after these grounds, the universe of delegation. It says, quote, or on such other grounds as the central government may specify, unquote. It means, in other words, that the central government, as if it is this legislature itself, can add any number of grounds in the years to come by notifications and government orders to deny entry to foreigners or to deport them. By a process of executive extension, theoretically, grounds can be added to deny entry or stay in India, none of these grounds having been seen or approved by this august House, which is the whole purpose of legislation. That's why I said excessive delegation. Then secondly, sir, comes the killer. The second proviso to the same section, clause 3, reads, provided further that the decision of the immigration officer in this regard shall be final and binding, unquote. Sir, अमेरिका में इमिग्रेशन जज, कनाडा में अपील बोर्ड, भारत में यहाँ एक इमिग्रेशन अफसर का संदेह ही अंतिम फैसला है. कोई अपील नहीं, कोई सुनवाई नहीं, सिर्फ एक अफसर की नजर और आपका पासपोर्ट, आपकी पहचान सब खत्म। यहां सर शब्दावली स्पष्ट है और सत्ता असीमित है। ये न्याय नहीं, ये निरंकुश राज है। एक अफसर का हुक्म अब आखिरी आवाज है। तीसरा बिंदु, पुनर्निरीक्षण करने की कोई भी ओवरसाइट संस्था कम से कम प्रथम स्तर पर तो देनी चाहिए। जब आपने इतने व्यापक इसमें अधिकार क्षेत्र दिए हैं सरकार को और एग्जीक्यूटिव को, कार्यपालिका को, बहुत कम ऐसे कानून देखे हैं मैंने जहां ऐसी संस्थाएं न मिले कम से कम प्रथम स्तर पे, खास तौर पर जहां किसी व्यक्ति के आने जाने और भारत में रहने पर इतना कड़ा प्रतिबंध लगाने का अधिकार क्षेत्र है, जो सिर्फ इस बार इमिग्रेशन अफसर को दिया जा रहा है। उसके ऊपर कोई ऐसा ओवरसाइट मैकेनिज्म नहीं है। ऑनरेबल गृह मंत्री ने लोकसभा में जवाब दिया था कि इमिग्रेशन अफसर के पावर्स उन्होंने ये कह के उड़ा दिए थे कि इमिग्रेशन अफसर पहले भी उसके विरुद्ध अपील नहीं होती थी और इमिग्रेशन अफसर 24 कसौटियों में, क्राइटेरिया में निर्णय लेता है। इस वक्तव्य में गलती है जो माननीय गृह मंत्री ने लोकसभा में दी इसी बिल पे, क्योंकि ये बात सही है कि पहले अपील नहीं होती थी, लेकिन पहले सेक्शन 3 भी नहीं था। ये अधिकार क्षेत्र नहीं थे जो अब आए आपके पास। इतने व्यापक इसमें बिंदु हैं जो पहले कभी नहीं थे। जब आपने अधिकार क्षेत्र, पावर्स, कोएर्सिव पावर्स, इंट्रूजन बढ़ा दिया तो संस्था भी आवश्यक है। तो ये जो तुलना दी है माननीय गृह मंत्री ने लोकसभा में गलत है। उन्होंने अमेरिका की तरफ भी संकेत किया। माननीय गृह मंत्री ने अमेरिका की ऑफिस ऑफ इमिग्रेशन की जो वेबसाइट है बड़े स्पष्ट रूप से बताती है कि वहां लगभग 700 इमिग्रेशन जज हैं, 700, और उसके ऊपर एक बोर्ड ऑफ इमिग्रेशन अपील्स भी है जो इन इमिग्रेशन जजेस का पुनर्निरीक्षण करता है। और मैं ये कहना चाहूंगा बहुत विनम्रता से कि अगर आप विकसित भारत बनना चाहते हैं तो हमें विश्व के उन सब विकसित वर्गों से उन सब की उत्तीर्ण चीजें लेनी चाहिए, न कि उनकी पिछड़ी कानून की आदतें। चौथा, ये जो आउस्टर क्लॉज कहते हैं कानून में, इसको फाइनल एंड बाइंडिंग को, जो इसमें डाला गया है, ये 200 वर्षों से मशहूर है, कई कानूनों में डालते हैं। और न्यायपालिका ने जब डाला है तो कहा है कि फाइनल कुछ नहीं होता कार्यपालिका के पास, फाइनल हमारा शब्द होता है न्यायपालिका का, न कि इमिग्रेशन अफसर का। लेकिन मुद्दा क्या है? मुद्दा यह है कि हमारी सरकार जानती है कि हमारी कचहरी कितनी चींटी की चाल से निर्णय देती है। यह भी जानती है कि इस कानून के अंतर्गत अनेक ऐसे याचक होंगे जो या तो कोर्ट कचहरी पहुंचने का सामर्थ्य नहीं रखते, या अधिकतम विलंब से जिनका मामला वैसे ही निष्फल हो जाता है, इनफ्रक्शस हो जाता है। तो इसलिए ये ओवरसाइट मैकेनिज्म आवश्यक था। पांचवा बिंदु, अनुच्छेद 3(2) के अंतर्गत कोई भारत से बाहर भी जाना चाहता हो, गौर करें, बाहर जाना चाहता हो, और यद्यपि उसके विरुद्ध कोई एफआईआर नहीं, कोई कंप्लेंट नहीं, कोई चार्जशीट नहीं, वो अभियुक्त भी नहीं है, तो भी बाहर नहीं जा सकता क्योंकि उसका वीजा खत्म हो गया है। सेल्फ डिपोर्टेशन जैसा अभी एक भारतीय महिला विद्यार्थी ने किया यूएसए में, वो 3(2) के अंतर्गत असंभव है। छठा, ये तो हुई वीजा खत्म होने की बात। अब वीजा न खत्म हुआ हो, उसके अतिरिक्त किसी का भी भारत से बाहर जाना इमिग्रेशन अफसर के आदेश द्वारा रोका जा सकता है। बाहर जाने की बात कर रहा हूं मैं, अंदर आने की बात नहीं कर रहा हूं। और इसके कारण इसमें, इस बिल में नहीं दिए गए हैं कि किन कारणों से वो कार्यपालिका, वो इमिग्रेशन ऑफिसर ये ऑर्डर, आदेश दे सकती है। ये कहा गया है, वही मैंने कहा, डिलाइटफुली वेग फ्रेजियोलॉजी, ओवर ब्रेथ ऑफ डेलीगेशन, मैंने अपने ओपनिंग में कहा था। इसके शब्द हैं 3(2) के, और ऑन सच ग्राउंड दैट द सेंट्रल गवर्नमेंट में ऑर्डर मे बाय ऑर्डर स्पेसिफाई, और उसके साथ लगाया गया ये प्रोवाइजो, द डिसीजन ऑफ द इमिग्रेशन ऑफिसर शैल बी फाइनल एंड बाइंडिंग। सर, सेवेंथली, George Orwell, in his worst Orwellian nightmare, would not have paid so much attention to foreigners, tourists, students, and so on coming to visit the ancient land of India with all its diversity. Our own big brother, however, does more with a further delightfully vague and blanket language of clause 3(3). I quote, the immigration officer may examine the passport or other travel document and visa of a foreigner during his, now mark these words, during his entry into, comma, transit through, comma, stay in, comma, movement within India, and also require him to furnish such information as may be necessary and appropriate, unquote. Sir, is this not the worst kind of license for arbitrariness, for harassment, for fear and intrusive behavior by a bureaucracy already known for its excessives and already functioning under a control-freak Sarkar? What is necessary and appropriate information is left to this officer, because he can ask anybody travelling from Goa to Bombay or from Khajuraho to Kashmir. What is necessary and appropriate information is left to this officer, not merely at the entry point, but right through the entire movement of the foreigner in India. Sir, it is not as bad as Indians and Pakistanis subjected to reporting restrictions in each other's countries. And certainly, personally, I don't care if you subject Pakistani visitors to it. But should we be even remotely moving in that direction for all other countries? Eighthly, with no appeal, no oversight, no accountability. Just raw, unchecked power in the hands of a few, who will ensure that no foreigner is unjustly detained weeks after lawfully entering India. No family will be torn apart by bureaucratic overreach. Let us take an example of an over-enthusiastic bunch of teenage foreign tourists get into a heated political debate and vigorously criticize this government. God forbid the thought. You don't need to make out a separate penal offence under our Sanhitas. You can put the fear of God in those teenagers holidaying in Goa or Khajuraho through the immigration officer. And more importantly, in all the friends of this teenager and the future travelers, by selectively harassing, detaining, and possibly deporting them on such vague phraseology. Mere suspicion can thus lead to all kinds of action with no adjudication worth the name. Because judge इसमें है नहीं, आप हाई कोर्ट जाइए या सुप्रीम कोर्ट जाइए, कोई अपील्स बोर्ड नहीं है, कोई संस्था नहीं है. ताज्जुब है मेरे इस सैफ हयात पर, ताज्जुब है मेरे इस सैफ हयात पर, जहां फैसले होने थे वहां सजाएं मिली. Ninthly, sir, clause 7 is one of the most egregious examples of excessive delegation coupled with overbreadth. It says, quote, by any order, direction or instruction, to prohibit, regulate or restrict the entry or departure of foreigners into or from India, unquote. No guidelines, no limitations for such instructions, orders or directions. And they are certainly not limited to the specific tests of national security, sovereignty, integrity, foreign relations, with which I am not quarrelling. These are untrammeled, uncircumscribed and unfettered language, phraseology and clauses. The opening part of the clause is without boundaries, and even the particularized sub-clauses in 7, clause 7 of your bill if you have it, seek to control the very facet of the existence of that poor foreigner. A few examples. It specifies, it can require the specification of times and routes by which a foreigner can enter, clause A. It can prohibit his departure, clause B, as I've already discussed. It can stipulate that he can be in India only at places specified, clause E. F requires him to present himself for examination anytime, anywhere. F small 4 asks him to report to authorities at specified times and days. F5 requires biometric information. F6, all this is mandatory, heavy penalties, prosecution. F6 requires subjecting himself to medical examination. And this is delightful. Last one, prohibits him from associating with persons of a specified description. This word is specified description. इमिग्रेशन अफसर वैसे कह सकता है किसी कांग्रेसमैन से बात नहीं करना, ये भी कह सकता है. आपकी शक्ल ठीक नहीं है. हेलो मंत्री, जरा सुनिए. As may be specified, unspecified. Tenthly, honourable members, was I wrong to call this a control freak Sarkar? Are these not mechanisms, sir?
मंत्री महोदय सुनिए, मैं दोनों आंख को खुली रखकर दोनों कानों से स्थिर मन से सुन रहा हूं। मैं आपको आश्वस्त
नहीं, अभी आपको जवाब नहीं देना, बाद में
नहीं, आप बोले।
मैं नहीं कह रहा हूं, अभी मैं नहीं कह रहा हूं आपका।
आप बोले प्लीज प्लीज। रेणुका जी, आग्रह है सीट पर बैठ करना बोले, बड़ी वरिष्ठ मेंबर है आप, प्लीज।
मेरा सौभाग्य,
आपस में कमेंट नहीं, प्लीज।
मेरा सौभाग्य,
प्लीज प्लीज।
मेरा सौभाग्य है कि आप इतने ध्यान से सुन रहे हैं। मेरा सौभाग्य है कि इतने ध्यान से सुन रहे हैं आप। Tenthly, honorable members, was I wrong to call this a control freak sarkar? Look at the thinking behind this bill. Does it think of foreigners as cattle or as en masse criminal gangsters? Is it so insecure that it wants this kind of disgusting suraksha chakra all around itself? Where are the standards, the boundaries, the tests for exercise of this mammoth power? Should we all rely on the good sense either of the sarkar or of the constable or of the immigration officer, that none of these open-ended words and clauses will be abused? Sir, 11th, the trinity of clauses, in particular 8 bracket 3, 9 and 10, 8, 3, 9 and 10, subcontract big brothers 24/7 surveillance of the foreigner to interesting entities. They subcontract surveillance 24/7 beyond Orwell to the landlord of premises where the foreigner stays. Oh God! कभी गलती करके किसी foreigner को घर पे नहीं रखिएगा. To the educational institution where he studies. To every hospital, medical institution and sleeping facility where he seeks medical help. Any and every information unspecified and unparticularized in the Act is left for the future discretion of the officer. And it must be furnished by service providers like landlords, hospitals, colleges, universities on strong pain of penalty prosecution. Large slices of civil society, friends, are therefore mandatorily by law co-opted as snooping partners with Big Brother on an all-India 24/7 snooping exercise by all foreign visitors to India. 12th, in this all draftsman architecture, the draftsman seems to have forgotten that we have a small little book called the Constitution of India and some of its core provisions. He forgot that unlike several developed nations, and this is very important, India is not developed in many ways, but in these manners it is more developed than other countries. Unlike several developed nations, we hold our head proud and high as a democracy because we guarantee several rights to non-citizens as much as to citizens by the Constitution. Yes. Many other countries limit it to citizen only. Is this a part of the bill? Baba Sahib, when he was asked about the heart and soul of our Constitution, identified two clauses, two articles, 14 and 21. They are the first thing which anybody is taught about our Constitution. He says the heart and soul. Both 21 and 14 or 14 and 20 apply to non-citizens as much as citizens. One, that is 14, guarantees equality, non-arbitrariness and substantive due process. The other, right to life and liberty, which is now non-suspendable even in a declared national emergency. And friends, I don't want to digress, I don't have time, but the jurisprudential journey of Article 14 is fascinating. Originally, I don't have the time, I'm not going to take time, just give me a minute. Originally, it was the equality doctrine. Don't treat equals unequally and unequals equally. From Royappa onwards in 1976, by court interpretation, 14 includes non-arbitrariness. What no reasonable person will do, apart from discrimination, separate from discrimination, non-arbitrary, second facet of 14. Third, from 1990s late or 1980s late, Maneka Gandhi's case added procedural due process. You must have due process of procedural kind in all laws, in all activities. And finally, for the last 5-7 years, we have substantive due process. Precisely what Benegal Rao Sahab, when he went and met Frankfurter in USA, had omitted from our Constitution, has been brought in by judicial interpretation. So all these are available to the non-citizen, not only to the citizen. 13th, sir, let me caution the Honourable Minister, if any of his eminent advisers are wrongly advising him to refer to apex court judgments like Muhammad Salimullah, Sarabanda, Sonowal 1, Sonowal 2, etc. They are judgments which are in favor of the government and the executive for one and one purpose alone. Not one of the 20 issues I am raising here are discussed there. They are for detection of foreigners. The mechanism to detect foreigners has been upheld in these judgments, and some acts which were found insufficient to detect foreigners have been struck down. So before you start quoting passages from these judgments out of context, I am giving an advance warning that none of them deal with clauses like 3, 4, 5, etc. in this current bill. 14th, sir, privacy and autonomy has now been judicially embedded in Article 21 by our Supreme Court. And I just told you that 21 applies to non-citizens as much as to citizens. Now, this bill blows concepts like privacy and autonomy to smithereens. I therefore beseech you not to be obstinate in not referring it to a parliamentary standing committee. Yes. Because I have no doubt, yes, and I hope my words prove prophetic if you don't refer it. I have no doubt that in its current form, this bill will face judicial invalidation in the next few years if passed.
It should.
15th, sir, 15th. The catalogue of foreigners guaranteed the same constitutional rights doesn't end with 14 and 21. You have Article 20 guaranteeing 3 very vital rights to foreigners and citizens alike. The right against retroactive offences, not that it applies in this case, but you must know that. Against double jeopardy, against self-incrimination. Then all the safeguards in detention available to a citizen under Article 22 apply to non-citizens also. Did you know that all the rights to freely practice, profess and propagate religion under Article 25 applies equally to non-citizens? These are the backdrop of the omniscient character of our Constitution, far ahead of the US Constitution, far ahead of other countries, which this bill, as I said, the draftsman forgot that we have a book called the Constitution when drafting. He believes that foreigners are here at the sufferance and the discretion of the executive or its factotums to be governed by a lawless regime with no safeguards. 16th, sir, vagueness and arbitrariness abounds, multiplies. There is a clause 14 which exercises control over third parties, not the foreigner, directing them to altogether close such premises owned by third parties on quote-unquote delightful, frequented by the foreigner. So if a foreigner likes to go to Khan Market shop and if the immigration officer doesn't like him very much, he can give a direction, not that it will be upheld, but I'm just giving an example. None of these vast powers need probable cause. There doesn't need to be an FIR, no charge sheet against that foreigner. It's the immigration officer, the big boss. In these days, 17thly, sir, of increasing dual citizenship. Increasing countries have dual citizenship. There is a clause 15 which may well be an anachronism. It gives the Indian central government to decide that 1 out of the 2 foreign citizenships of a foreigner coming here, 1 we will deem to be the correct citizenship. Read the clause. उसको citizenship मिली है A और B से, भारत सरकार निर्णय करेगी कि कौन सी citizenship उसकी लागू होती है, दोनों में से एक. We are not synced with the international global trend of dual citizenship. 18th, sir, there is a clause 17 which runs into 13 sub-clauses. 17 is almost a page and a half. 13 sub-clauses. It puts one of the biggest bureaucratic loads on all land, sea and air carriers transporting any foreigner. Most airlines should now only fly non-foreigners. The entire transportation industry must be having nightmares on seeing clause 17. Because if you default in the smallest form, comma, full stop, which you have to fill up for every foreign passenger, you are liable to severe penalties and prosecution. Compliance cost is one inevitable consequence. Bureaucratic harassment is another inevitable consequence. 19th, sir, I'm ending in 3 or 4 minutes. Well before my time today, I seem to have ample time. 19th, clause 26. I mean, every head constable in this country would love to have clause 26. They should frame it up in their house and put it as a framed. Clause 26 elevates the head constable as the supreme coercive officer. Oh. Supreme. You are all lawmakers. You have seen hundreds of acts where there is not below the rank of superintendent, not below the rank of commissioner. You have so many acts, excise this, that. यहाँ उल्टा कहा गया है कि अंतिम अंततोगत्वा कांस्टेबल का अधिकार क्षेत्र होगा. ऑफ कोर्स ऊपर कोर्ट होता है, जो कोर्ट जा सके, जिसका सामर्थ्य हो, लेकिन जहां तक एक्ट का सवाल है, मामला हेड कांस्टेबल के वक्त के स्तर पे खत्म हो जाता है. The enormity of the executive power and the great potentiality of its misuse, as reflected in the bill, is in inverse proportion. Power is that high, the person exercising the power, inverse proportion to the status given to the person who is the wielder of that power. The higher the power, the higher should be the status. It's an inverse proportion here. Even lesser acts have higher and greater authority specified. This approach can only be ascribed to a mindset treating foreigners not as individuals with dignity and respect, with identity, but as objects of our contempt and disgust.
Oh, shame.
Sir, in the end, you will be surprised that I have found something in the bill worth retaining. Clauses 21, 23 and 25, 24 and 25 mitigate some of these draconian facets by mercifully, thank God for small mercies, providing for compounding of offences. These must be retained. Of course, the whole bill must be referred to a standing committee. Sir, I hope the Honourable Home Minister will heed some of our advice and refer this unconstitutional bill to the appropriate standing committee. Yes. Otherwise, we will all have to say, guilty till proven, jailed on a guess. Justice here is a game of chess. Injustice dressed as immigration law is still injustice.
Yes.
It is a bill supposedly in the name of law and order, but it is actually in the service of chaos.
Yes, yes.
न्याय नहीं, यह तो निरंकुश राज है. एक अफसर का हुक्म है, आखिरी आवाज है.
अफसर भी कांस्टेबल.
जब कानून की परिभाषा अफसर की मर्जी बनेगी, तो लोकतंत्र की सांसें घुटने लगेंगी. यह बिल सुरक्षा के नाम पर नागरिक स्वतंत्रता की हत्या का पहला कदम है. कोई पारदर्शिता नहीं, कोई जवाबदेही नहीं, सिर्फ सरकार और अधिकारियों की मर्जी से तय होगा कि किस देश में रहने का हक है, किसको देश में रहने का हक है और किसे नहीं है. क्या यही नए भारत की सोच है? ये विदेश नीति का मामला नहीं है, ये भारत के लोकतांत्रिक मूल्यों पर हमला है. यह बिल विदेशी नागरिकों के लिए बना है. मैं मानता हूं कि ये नागरिकों, हमारे नागरिकों के लिए नहीं बना है, विदेशियों के लिए बना है, लेकिन इसकी छाया भारतीयों तक पहुंचने में देर नहीं लगेगी. आज ये संदेहास्पद विदेशी का निशाना को निशाना बनाता है, कल यही तंत्र भारतीयों को भी क्यों नहीं बना सकता निशाना. इस प्रकार की नियंत्रण सन की सरकार, कंट्रोल फ्रीक सरकार, एक स्तर पर अपनी असुरक्षा की मानसिकता दर्शा रही है. शायद आप सोच रहे हैं, बुलंदी देर तक किस शख्स के हिस्से में रहती है, बुलंदी देर तक किस शख्स के हिस्से में रहती है. बहुत ऊंची इमारत हर घड़ी खतरे में रहती है. बहुत बहुत धन्यवाद.
श्रीमती